Good morning. Uh, the advocates who are having social interest and want to prevent any sand mining, mining, and those who are residing nearby rivers had occasions to sustain difficulties and hearing the hue and cry of farmers because of sand theft cases. And you see daily multi number of bail and anticipatory bail applications are being filed for sand theft. This case would help you to file how to prevent those sand mining, because recently Supreme Court came on 5th, 8th May, came heavily on these activities. See, the district authority called for e-action without preparation of district survey report. Actually, there was a district survey report, but that was not renewed, which was mandatory to be renewed every 5 years. And despite that, they have issued this hurriedly issued e-action notice. Subsequently, they have also sanctioned the person LOI who succeeded. These things have been quashed by the National Green Tribunal. National Green Tribunal Act 2010, 19 of 2010, which has to be read with several Environment Protection Acts. So all these things, so many acts are there, Environment Protection Act, and you have to file applications according to those provisions of the act. And the rules are there, corresponding rules are there, and EIA notifications is also there. So the the Supreme Court has held why the DSR is mandatory. This is a regulatory regime introduced from time to time, increasing the width as well as depth of scrutiny before granting environmental clearance for sand mining. District survey report is a document of seminal importance as it enables informed decision making. Preparation of DSR as per procedure prescribed for its preparation under Appendix 10 read with 7, para 7 required to be followed meticulously. A valid and subsisting DSR alone can be the basis for application for grant of EC. A draft DSR is untenable for grant of EC. Preparation of reports and appraisal of project by DEIAA and DFAC shall be on the basis of valid and subsisting DSR. DEIAA and DEAC are recognized as authorities vested with statutory duty of preparing DSR every 5 years, and this duty compels them to have comprehensive and real-time perspective of environment position of the district, including its eco-sensitivity and other fragilities. See, the thing was, they have upheld the judgment. Before commencing the judgment, the Supreme Court has said the unregulated sand mining disrupts riverine ecosystem, alter natural flow patterns, leads to erosion and habitat loss. Aquatic biodiversity suffers as spawning grounds are destroyed and water quality deteriorates. So the destabilization of river banks increases flooding, risking human life and animal habitat alike. Moreover, the illicit sand traffic often operates under the shadow of organized crime. These things they have said, and they have also clearly stated under what provisions these applications are filed. The original application invoking section 14 and 18 of the National Green Tribunal is being filed, original application. After filing that, they used to appoint a committee. They used to joint committee comprising of Central Control Board, State Pollution Control Board and District Magistrate. So these things are there. Pending draft DSR, the authority granted license to successful bidder. Therefore, the Supreme Court said this is not correct. It is liable to be set aside. Therefore, they have set aside it. This is the AR 2025, Supreme Court 2503, AR 2025, Supreme Court 2503. State of Uttar Pradesh and another versus Gaurav Kumar and others. See, fantastically, the state government went on appeal because this field is much rich field. If these things are there, you go through the entirety of the section 6, para 6, para 7, para 8, all these things gives some clear picture about how the authority is by breaching the regulated statutory procedures before granting license. So many guidelines, monitoring guidelines were stated in the judgment. Finally, they said even before expiry of 5 years, but a reasonable estimate to work as benchmark is policy consideration. Therefore, district report is documental semitally as established informed decision making. This is what they finally said, and they have upheld the case of the NGT, National Green Tribunal, which cancelled the grant of license for mining, sand mining.